Hi, my name is Josh Blackman, and I'm the president of the Harlan Institute. It's my honor to welcome you to the 2021 Harlan Institute Ashbrook Virtual Supreme Court competition. This year, we're arguing the case of New York State Rifle and Pistol Club versus Bruin. We are now in the Final Four match, and we have two esteemed teams. From California, we have Elise Spenner and Audrey Young. And from Minnesota, we have Avi Garg and Zachary Kirkaby, and they'll be presenting the case now. Petitioners, begin whenever you're ready.
Mr. Chief Justice, and may it please the court. My name is Elise Spenner, and my co-counsel is Audrey Jung. Would the court benefit from a brief presentation of the facts, or should we jump straight into our oral argument?
Please, facts would help.
In September 2014, New York residents Robert Nash and Brandon Koch applied for concealed carry licenses to carry a firearm outside the home for self-defense. Though Nash and Koch met the requirements, officials denied both licenses for lack of a special need or proper cause. The two men and the New York State Rifle and Pistol Association sued Kevin P. Bruin, the head of New York State Police, and Justice Richard McNally, a judge in New York's 3rd Judicial District.
New York's proper cause requirement is unconstitutional after consideration of text, history, and tradition, and under any level of heightened scrutiny. The ruling of the Second Circuit cited Kuchalski to erroneously find that carrying outside the home is a second-class right. But this court said the opposite in Heller.
How many circuit courts, counselor, have ruled the same as in New York that the Second Amendment does not guarantee a right of carry outside the home?
Your Honor, there is currently a circuit split, and which is why this case has come to the court. We recommend that the court resolve.
Right, but how many courts went one way? How many courts went the other way? What's the split right now? What's the breakdown?
We believe it's more of a kind of like a half and half split. I believe it may be the 1st, 6th, and 7th circuits or so, which have ruled that carry does not extend out to the home, and then an equal number have ruled the opposite direction.
Yeah, I take it, though, that the various court of appeals in different states are looking at different state regulations about what you have to show to be able to get a permit. In the New York case, what specifically, again, are they requiring?
New York is requiring that applicants demonstrate an atypical need that separates them from the general public to receive a concealed carry license.
Okay, and do we have anything in the record about how many people who apply get turned down versus how many people who apply get approved, or is it just we know that these petitioners got denied?
Well, Your Honor, I don't have the exact numbers, but I do know that the majority of people are denied their licenses even when they demonstrate a sufficient need. For instance, traveling in a high crime area at night or distributing large amounts of cash hasn't qualified, even though these applicants have demonstrated that they have a separate need distinguished from the general population.
Well, so counselor, if you're saying a majority, and I'll take your answer. If a majority they're being granted, they're being denied, some are being granted, right? Right? The number is not zero.
Yes, some are being granted.
Why is it not sufficient? This is not an absolute violation of the right. The state's taking certain precautionary measures, perhaps, for public safety. The fact that it's not zero, why does that undermine your case?
Your Honor, a specified subset of the population should not be the only ones that receive their Second Amendment right. It should be a right that is generally accessible to the public.
But you're jumping to the question, what is the right? I mean, maybe we should start there. What exactly does the Second Amendment protect? Is it an unadulterated, absolute right to carry for any reason whatsoever under any circumstance? What exactly is this right you're speaking of?
No, Your Honor, the Second Amendment protects the right to keep and bear for the people and not a specified subset. And so while courts might be right in upholding certain long-standing restrictions as upheld by Heller.
The New York law is from 1911, right? The Sullivan law, that's 100 years. That's pretty old.
Yes, however, even though this may be an old restriction, it's not narrowly tailored and still conflicts with the Second Amendment.
Right, but now you're jumping to strict scrutiny. I think we're sort of moving all over the place. Why do you assume strict scrutiny is governing here?
Your Honor, we believe that strict scrutiny governs here because the Second Amendment is a fundamental enumerated right. And
Heller say that? Did Heller say strict scrutiny?
Heller advocated for heightened scrutiny, and
look, if Heller wanted a strict scrutiny, they could have, right? It's a known phrase. They avoided that. I mean, that might have been a compromise for whatever it's worth, but they said heightened. So why do you assume strict?
We advocate for strict because that is the same treatment that other enumerated rights However, we believe that under any form of heightened
but
scrutiny,
there's some First Amendment cases that are judged intermediate scrutiny. That's not true. There's some aspects, with O'Brien and otherwise, we have intermediate scrutiny. I think that's right. It's not always strict scrutiny for enumerated rights.
perhaps not, Your Honor. However, we feel in this case, given the severity of the restriction on the fundamental right, it is important that we.
Let me ask you this, counsels. There's sort of two ways you might think about what the level of scrutiny would be. One, what you just said, if it's a severe burden, maybe strict scrutiny. If it's a less than severe burden, maybe intermediate review. And there's some court of appeals that kind of talk about it that way. Another way to talk about it would be, well, if you've got sort of direct violation of the right to have a gun, like in a home or something, that's strict scrutiny. But like under the First Amendment, if there's some content neutral reason that you're doing it, like we're worried about people carrying guns all around and creating even more crime by having guns everywhere on the street, then that's intermediate review. Are you arguing for sort of severe strict scrutiny, less severe intermediate, or are you arguing more that this is really a core violation, so it should be strict scrutiny rather than some secondary effect, so it should be intermediate?
Well, Your Honor, we're arguing both. First, the law is extremely restrictive, as evidenced by numerous case law. And second, New York has not demonstrated that its law really does meet a compelling interest in protecting public safety. There is a lot of dispute when it comes to studies, and we don't believe there's a lot of dispute when it comes to studies showing that New York's law may not reduce violence.
But but the evidence is, uncertain, dispute, to use the word, isn't the better proposal to simply defer to the state, let the elected branches decide? Why? If there's any doubt, why should the court second guess?
Your Honor, it is the role of the court to protect each citizen's essential Second Amendment right, and it's not the job of the legislature to re-engage in interest balancing between public safety and a core Second Amendment right when it means impinging so drastically on that right.
And interest balancing was specifically rejected by the court in Heller, where they said it's not the role of the judiciary or even the legislature to determine on a case-by-case basis whether this right is really worth insisting on.
Okay, explain to me, I understand your strict scrutiny, why this might have real trouble. Explain to me why, even if we decide it's an intermediate review, which is what lots of these Second Amendment cases are getting in the lower courts, why under intermediate review is this particular New York law, because of its such limits, why would it violate intermediate review anyway?
Well, let's look first to First Amendment case law, McCutcheon versus FEC, McClellan versus Coakley, Packingham versus North Carolina. Intermediate scrutiny demands narrow tailoring. And New York's law, by definition, does the opposite. It restricts access to the right to carry to only those that demonstrate that they are different from everyone else. And so we think that on face value, this does not pass intermediate scrutiny because it subjects the right to only a select few.
I take it the intermediate language tends to be, is it substantially more burdensome than necessary? Not just, is it the least restrictive for strict scrutiny, but is it substantially more? Why is this law? Because they're concerned in New York about lots of people just carrying guns around, say, go to some demonstration. And now, if everyone can carry a gun, you could have a real messy demonstration. And New York's worried about that. Why is this law substantially more burdensome than it needs to be?
Well, Honor, first, we would argue that first, there are 43 states that operate under shall-ish regimes without demonstrably worse problems. And when it comes to having a dense population as well, 7 out of the 10 largest cities have shall-ish regimes, without demonstrably worse problems. And so we argue that the law fails to meet a substantial.
Doesn't New York permit carrying for your clients for hunting and target shooting?
Yes, Your Honor, New York permits.
Why is it not sufficient?
Because our applicants believe that they have a need and have demonstrated a need to carry when they're going to work and when they're going home for self-defense in that case, and they do not currently have the right to do so.
Now, let's talk about open carrying for a minute, because I know this comes up in a lot of the briefing. Does New York allow open carry?
Well, we believe for the purpose of this case, no. New York does allow the public display of historical weapons, for instance, and may allow the display of rifles, but we believe for the cases of national.
Would you be okay if New York gave your clients a permit to open carry?
Your Honor, it depends. While open carry would allow one avenue to access their Second Amendment right to carry, an independent analysis would have to be conducted to decide if open carry was sufficient for people in New York City. For example, in Heller, they found that a handgun was the most preferred weapon of use for self-defense. If concealed carry proved to be more preferred by New York residents than
But is that a historical inquiry? You're just basing on whatever's more popular today. I mean, isn't there more history behind a right of open carry than a right of concealed carry?
Well, Your Honor, while 19th century courts may have tended to prefer open carry, they upheld open carry on the presumption that at least one form of carry must be widely available. And we believe that concealed carry, while open carry might have been preferred, at this time, concealed carry may be the way for citizens to best exercise their Second Amendment rights, and thus could be preferred here.
Okay, Counselor, your time's up. Thank you so much. If the respondents can please come back on screen. You have 15 minutes and begin whenever you are ready.
Thank you, Mr. Chief Justice. And may it, is Justice Kelso here? Should I wait for?
I think you want to step away for a second.
Okay, I'll just wait a second.
Thank you, I didn't. There he is. Okay. Justice Kelso, everything ready? Proceed.
Yeah, I'm ready to go.
Okay, 15 minutes. Go ahead.
Thank you, Mr. Chief Justice, and may it please the court. New York's proper cause requirement falls well within the text, history, and tradition of the Second Amendment. We know this because of the evolution of laws, starting with pre-founding Statute of Northampton equivalents, then surety laws, and finally the permitting regimes at issue today. However, there's a narrower basis on which this court can affirm the Second Circuit, which is that petitioners in this case live in Rensselaer County, where they can openly carry rifles and shotguns. And I'd like to spend
let's just start there. I mean, I think we have some disputes in the record, right? I asked your friend 5 seconds ago, can you open carry? She said no, and you're telling me here yes. Maybe just what is the state of the law in New York regarding open carry, please?
Yes, so I think they two places for why you cannot open carry. First, on page 12 of their brief, they cite this USCCA website where it says that you can't openly carry in New York. The problem there is that it's talking about New York City, which does have a law prohibiting openly carrying of shotguns or rifles. And if you look at the rest of the website, it is very clear that the rest of New York State, you are able to openly carry rifles and shotguns. And then the second one is that the complaint—
Do you need a permit? Do you need a permit to openly carry a rifle in Rensselaer County?
No, you do not. There are some restrictions on like length and sort of bullets, but that's a different—
And could you use that weapon, the rifle you open carry, for self-defense in Rensselaer County? So you're walking down the street in Rensselaer County and someone comes to attack you. Can you take that rifle off your shoulder and shoot someone? Is that legal?
Yes, you are allowed to carry a loaded gun, and you can, if it is self-defense.
And then, so what happens if someone in Rensselaer County decides to visit New York for the day? Do their rights become extinguished?
New York City does have a ban, and that's where.
So I guess your argument is you can carry all of New York except for the place which is the highest crime rates in the state, which is probably the city. So let's just table that argument. I appreciate the factual clarification, but proceed with the argument why. Let's assume that you can't open carry in New York City, and that's what we're talking about. Okay, go on.
Yes. So the argument on proper cause is just the idea that the Statute of Northampton and surety laws provide sort of tradition for these proper cause requirements, right? That the surety law system is almost the exact same thing, and it starts in 1836, where you could sort of ban weapons unless someone could show reasonable cause that they had some sort of reason to fear or terror of someone else. And
so let's talk about this terror for a minute. I mean, we have all this argument in the briefing. The Statute of Northampton, which is almost 700 something years old, talks about carrying for the terror of others. Wouldn't that be something closer to brandishment or causing an assault where you create apprehension? I mean, just carrying a gun in your holster that no one can see. How does that fit into the rubric of the Statute of Northampton?
Well, Your Honor, a concealable weapon is inherently something that can be interpreted as dangerous and inspire terror.
How does no one? But if it's concealed, how do you even know if it's there? No one even knows. It's under your jacket. It's under your shirt. No one knows it's there. How's it inspiring terror?
I think the reason that I think the main point we'd make is that fear or terror was not the rule in sort of all of these laws, right? That there are some laws such as New Hampshire, which we cited in our brief, where there was no fear or terror clause, and then the main restriction was sort of dangerous weapons. And dangerous and unusual weapons is what handguns falls into. I think the second point we'd make there is that even if you sort of buy petitioner's argument that this is fear or terror. And I think it's sort of important to sort of see statute in Northampton, not on like the particulars of the law, but just the kind of overarching idea that it's a very discretionary system, right?
Well, let's just put the statute of Northampton aside for it. This is a law from the 1300s, really old. We come to England, we come to America, and we have lots of cases in the 19th century, which is more recent, which discuss a right of carry being sort of a fundamental right. How do you square with those cases from Georgia and other states?
Yes, so I think the Georgia case, the non-Andrews, whatever, these cases, I think they have a kind of disclaimer there. They say that it's fundamental insofar as like you don't have another way of exercising that right, right? So in those cases, Georgia is a great example. It says that you can't carry it, but if you were able to openly carry rifles and shotguns, etc., then presumptively,
right. But we said a minute ago, New York City does not allow open carry. So maybe for Zachary, so we balance that a bit. I mean, how do you square the Georgia case with the fact that New York City bans all types of carry?
Well, the petitioners live in Rensselaer County, and we focus.
I know, but they travel, right? We have a right to travel around. We're not limited to Rensselaer County. It's not want to go see a Broadway show. I don't know. You want to do something in New York City? Just focus on Manhattan for a minute, right? There's no alternative method of carrying in Manhattan.
Okay, I think the main difference there is that those laws were complete bans, right? So I think those laws don't get to sort of the text, history, and tradition behind proper cause requirements because they are about complete bans. And I think the cases that considered complete bans, right, those cases that were about surety, not cases, but laws that were about surety laws like Statute of Northampton, I guess State versus Huntley, which petitioner site would be a good example there. Those are more of the cases that get more at the sort of idea of proper cause requirements.
Do you think New York State could ban carry, and I know they have this good cause standard, could they ban carry altogether? Absolute ban on concealed carry, only open carry. Could they do that?
Absolute ban on concealed carry. If they leave an open carry, yes, they could do that. They can't ban both at the same time.
Why can't they do both?
Let me ask you, because it's the best you can hope for is that we're going to apply intermediate review to this in terms of the basic case law. Under that, you've got to demonstrate a substantial government interest that supports your statute, and you've got to show that it's not substantially more burdensome than it needs to be. Just in briefly, sort of, what are your substantial interests that support your existing law? And then second, I'm going to ask, why is it yours, which is more restrictive than a lot of other states? Why isn't it just more burdensome than it needs to be? But first, what are your substantial interests that support this New York law?
Well, Your Honor, the substantial government interest in this case is overall public safety, which is one of the most important types of government interest. In the case of New York, they find that shall issue regimes are insufficient in properly screening. On page 15 of our brief, it talks about how a majority of crimes committed are by first-time offenders, something where a shall issue regime does not take into account and would insufficiently address that, doing not enough, whereas the New York's proper cause system is more likely to better filter out who is a threat to overall safety.
Okay, now why is your way of doing it, which is a whole lot more restrictive than a lot of other states regulate a carry, why isn't yours just more burdensome than it needs to be? Why does it have to be as limited as your New York law is?
Well, New York's system shows that page 15 of our brief talks about how shall issue is simply insufficient. So New York's current system does match the constitutional right in question, in addition with government interest of trying to find the best balance for the two.
All right, but let's assume strict scrutiny governs, right? Do you lose? Can you guys win under strict scrutiny?
We cannot win under strict scrutiny. Okay,
so it's basically, I think Justice Kelso's question is intermediate scrutiny or bust for you. Okay.
That,
right. Yeah.
Justice Kelso sets up a dichotomy that it's either, whereas we feel that, like, first we have to look to history, and then should history become unclear, then we can move to intermediate scrutiny. We find that one can uphold New York's law under both history and intermediate scrutiny, but not strict scrutiny.
Okay. All right. So let's talk about Manhattan for a bit, right? Could the city of New York State ban carrying the entire island of Manhattan, that every square inch of Manhattan Island from downtown to uptown is a sensitive place, just doesn't the entire island a sensitive place due to, I don't know, population density? Could New York do that?
Well, Your Honor, it is unlikely that they would be able to.
No, that's my question. Could they do it? That's what I'm asking you. Assuming they have the votes for it.
No, Your Honor.
Why not?
As they'd just be blanket making the entirety of Manhattan Island a zone where one cannot have a gun. That's just simply over-inclusive, as there are differing parts of Manhattan that are going to have differing population.
All right, so let's say you
densities.
can't carry a gun within 200 feet of a school. Could you do that?
I think that the idea here is that sensitive places restrictions have to sort of view, like, you have to look to whether or not you're sort of infringing on another constitutional right. So I think 200 feet, like, maybe we can have inquiries over whether it's 200 feet, 100 feet, whatever. But I think
probably, right, but whatever radius you use, Manhattan, there's a school in almost every block. So you're basically wiping out the entire island of Manhattan. What I'm trying to get across is how are you defining, like, let's say we rule against you, right? Let's say we rule that the petitioner have the right to a permit. How then should New York decide what is a sensitive place? Can they just basically expand sensitive places even more broadly, not just a school government building, but even something near a government building?
Well, I think there is basically no world in which the right to carry in New York City will be something where you can carry a gun around uninterrupted, right? Like, I think almost like every block, if you enter a building, etc., there is going to be a reason for you to have to relinquish your gun.
Well, every public sidewalk, can a public sidewalk be deemed a sensitive place?
I think that's probably, like, most public sidewalks, unless it's obviously
Times Square. Can you carry in Times Square?
Time, place, and manner, maybe, like, some days you can't, some days you can, right? I think that probably in general you can, because otherwise it is quite restricted. But I think the main point is that these are a lot of tough questions.
Subway. What about the subway?
No, Your Honor, as there is a much higher density of people at any given moment on the subway, and the chances of
I don't know. There's some public sidewalks that are pretty dense. You ever see Manhattan? People just walking shoulder to shoulder. They're almost as dense as a sidewalk. Why is a public sidewalk different than a subway?
I think the subway is probably more, like, dangerous because it sort of infringes on other people's ability to sort of get to work.
How is the subway different than a sidewalk? People walk to work sometimes. Not everyone takes the subway to work. And again, if you see a Manhattan sidewalk, man, the people are like inches away from each other during rush hour times.
Again, I know it's like a tough line to draw, but I think a subway is something where people are, they're trying to exercise the sort of right to get to work. And if you're scaring them off of the subway because people can start openly carrying or concealed carrying guns.
No, only conceal. We're not talking open now.
Yeah, I think that it becomes a bigger public safety issue at that point because of the sense that people, A, are trapped into the subway car. And I think there's also statistics that sort of back up my sort of statements that, like, subways are more likely to have shootings than
let me ask this. I mean, all these various nuanced questions about different places, that really is kind of a legislative balancing kind of issue about policy in all different places. I suppose my question is, why should we, the courts, be engaging in all this kind of balancing? Why shouldn't you basically take the position that because of all these different things, it ought to be left up to the legislature and the courts shouldn't be involved in this balancing at all?
I think, Justice Castro, that is our position, that because of that sort of balance, that state sort of judges can sort of set up different sort of boundaries in New York City than they do in upstate New York. And that makes a lot of sense because of the sort of different legislative interests that exist.
But do we usually think that constitutional rights vary based on what part of the state you're in? Does the Miranda warning differ if you're in the city versus upstate, or does the right of search and seizure? Do we usually think of constitutional rights varying from zip code to zip code?
Well, Your Honor, while constitutional rights may not vary from zip code to zip code, there is certain provisions for them to have weaker protections in different areas. The Fourth Amendment, for example, one has the right for protection for themselves, their home, and their car, yet there is weaker protections for their car, whereas a full warrant is required to search one's home.
I get that. So, I mean, definitely between carrying in the house and carrying on the street, there's going to be different standards. I'm with you on that one, right? But I'm saying if you drive your car on the highway from Midtown Manhattan to upstate New York, the state trooper doesn't have a different guidebook of how to do search and seizure depending where he pulls your car over and what part of the state you're in.
I think to that issue, there is sort of one sort of analogous restriction, which is obscenity laws, where different states can sort of set different boundaries of obscenity. And I think in general, the reason for that is because there's a text, history, and tradition behind that, right? Similarly, in the Second Amendment context, there is a text, history, and tradition behind sort of fairs and markets having different sort of restrictions than other places. And I don't think it's fair to say that it's a different right. It's just saying that the government interests are different and those sort of balance out in different ways.
Okay.
And I think I'd also like to continue just to sort of get to the start of the scrutiny point, right? The reason you should be thinking about preferring intermediate scrutiny over strict scrutiny is because it's the one that best coheres with the history. For example, laws that Heller set out as presumptively constitutional, like bans on felons carrying weapons, would fail under sort of exacting scrutiny or strict scrutiny or whatever they call it, because there's non-violent felons like Martha Stewart, where there's basically no reason for why they should not be having a gun. But overall, when you look at it as a reasonable fit, that is when that law starts to make sense. And I'd also just like to quickly respond to sort of their warranting for why we should be using intermediate strict scrutiny. They basically make up this argument that the right is to carry outside the home. You get limits, but that limit has to be sort of strict scrutiny because it is a core right. But we think that sort of begs the question, right? Because once the historical analysis is unclear, then that means that we don't know what the core right is. And that to sort of determine what the core right is, we need to use intermediate scrutiny to find out.
Okay. Any other questions? All right. Thank you, Counselor. 5 minutes now for petitioner's rebuttal. And whenever ready, may begin.
May it please the court. Respondents argue that text, history, and tradition support New York's Sullivan Law, including the Statute of Northampton, surety laws, and modern restrictions, and that the public carry regime would survive under intermediate scrutiny because first, the county still allows some access to open carry, and second, that New York's proper cause requirement is narrowly tailored to filter out all those people who are a threat to public safety. Looking first to text, history, and tradition, let's start with the Statute of Northampton. As clarified by numerous case law, Northampton refers only to terrifying carry of dangerous and unusual weapons, which was also clarified by Hawkins's historical treatise. And basically, this differs from New York's proper cause standard because Northampton starts with the baseline assumption that you have the right to carry and then restricts if you carry in a terrifying manner, whereas New York assumes that you don't have the baseline to carry and then it requires a popkin to show.
Isn't the analogy a little bit off? Because New York isn't really, if you carry in a terrifying manner, there's brandishment and other similar crimes. Isn't really, I mean, how do you go from Statute of Northampton to basically a shall issue regime, right? In other words, why is there a constitutional right to a shall issue regime? Did any state ever have such a regime before?
Well, Your Honor, the Second Amendment codified the right for all the people, and we believe because it's a fundamental enumerated right, it must be granted to the people based on an objective standard not determined by the government.
Yeah, but where do you get that from in text and history? I mean, I understand 40-something states have a shall issue regime, but how do you build that from the historical right that there's this that you must get a permit? It's a shall issue.
Well, Your Honor, 9 out of 13 states have amendments in their constitutions that enshrine a right to carry for self-defense.
But did they say carry for self-defense in the text of those state constitutions, or they say something different?
I believe that most of the state constitutions expanded on the Second Amendment to clarify that the right was not a collective one, but an individual one.
Yeah, well, not everyone agrees with Heller, and I think the state constitutions are a little bit more ambiguous. But maybe a more broader question. I'll ask you the same question I asked before. Should your right to carry extend to the subway in Manhattan?
Your Honor, we believe so. And the reason is that the subway isn't a sensitive place because sensitive places traditionally also restrict access to certain people. The subway does not. And because it's available to the general public, we believe that open concealed.
What about in public parks?
Your Honor, it's the same thing because it's a place open to the general public. Where the
what
general
about a
public
courthouse? A courthouse is open to the public. Anyone can walk in.
However, a courthouse is a government building, and there are longstanding restrictions on carrying government buildings that the court in Heller would uphold.
So why is a park different from a government building? They're both government entities. A public park is
Your Honor,
government.
The difference is that the government doesn't bar certain people from going into the park, whereas they do bar people from going into the park.
What about a park during a festival? You know, they have like, some sort of concert or something in Central Park. Those have concerts there. Would that be different?
Your Honor, during a festival, we believe that the people holding the festival could apply for time, place, and manner restrictions similar to that of the First Amendment.
No, but the city of New York wants to ban carry during all Central Park concerts. Whenever there's think of the big green in Central Park where they have concerts.
No, Your Honor, we believe this would not be constitutional because New York could hold festivals any day in that park, and that would restrict the general public who say might be in a different portion of the park.
What about standing in front of
this council? Let me ask you this in terms of all these variations. do you want this court in this case to render an opinion that sort of goes through and sort of says what New York can do? Or would you be satisfied if we just said it's strict scrutiny, the current law can't pass strict scrutiny, but then leave it up to the legislatures to decide, whether they want to try to come back in like the park or the subway or whatever, to do something specialized? In other words, are you asking us to sort of resolve all these issues that are being asked now? Or are you just asking us to say it ought to be strict scrutiny and then lower courts, you go back and figure out all the different areas?
Your Honor, we believe that saying strict scrutiny should be applied to New York's proper cause regime is sufficient. It is not the place of courts to get into the nitty-gritty details about which individual cases would fall under constitutional or not constitutional public carry restrictions. We think that should be left up to individual case-by-case lower courts.
Okay. Any further questions? All right. The case is submitted. Thank you both. Both teams can come back onto the camera. Congratulations. This was a very, very strong round. By now you've gone through, I think, 3 or 4 of these rounds, so you're sort of old hat. You sort of know what to expect. But you can tell we're sort of dialing up the intensity at each level and interrupting you more, challenging you more, and asking you to draw very difficult lines. One of the trickiest parts of oral argument is when the judge is trying to pin you on a position. Because once you say yes or no to a position, it's okay, you said yes to this, but no to this. How do you reconcile those positions? And you don't always know where I'm headed. Maybe you do know already by this point, but you don't always know where the judge is headed with what kind of questions. I try to think of some new ones actually, where they're going to be heading. So you have to be very careful when you sort of make these stipulations, yes to this, no to that, because then you sort of pin yourself in. I think Justice Kelso was like, do we need to answer any of these questions? No, we don't need to answer any of these questions. He's exactly right. But I'm still making your lives difficult. I also like the way you handled the issue of open carry. I've looked into myself. I think the record's actually unclear. I don't exactly know what the law is, and I think both Audrey and Avik made a fair representation of the factual record. I think it's actually somewhat disputed. I like actually you parry saying, well, you can open carry in upstate New York, but that only gets you so far because you can travel down the highway. I think you both had a good handle on the history. Again, I think the history is somewhat in dispute. There's good arguments in the staff of Northampton on both sides. I like that the respondents talked about briefs with page sites, which is that's something that helps the judge, because you say page 15, page 12. Okay, I have the brief in front of me. I can flip to it and see what you guys are arguing. And it also helps during your sort of response rebuttals. Like they said on page 7 this, and then you sort of go on there. And I think that really does help you. You both are pretty poised. I appreciate that Audrey and Elise are not actually in the same city. One of them is in San Francisco, one of them is in Los Angeles. They're not even in the same place. They couldn't be in the. I didn't realize until recently. I feel stupid, but like they're not actually in the same city. But even over Zoom, I thought your rapport was pretty good. You sort of handed off one to the next. It was a good balancing of the work. Avik, you probably spoke a little bit more than your teammate, but you got to. I think the balance was okay. And also your courtroom demeanor, I thought was professional. There wasn't crosstalk. In other words, when we started talking, you sort of shut up and you didn't like try to talk over us, and you sort of just waited to hear. And you always answer questions like yes, but, or no, however, or yes. And maybe once or twice, it depends. I don't like the depends questions. Sometimes you think you have to go down that road, but you build credibility by not filibustering my questions. You consistently said yes, but no, Your Honor, because it's a weak spot, but you got to immediately pivot from a strength to from a weakness to a strength and make yourself in a lot stronger position. But these were really professional things, and I say this every time, but you guys could be in law school tomorrow. The level of advocacy you're doing are things that I would coach my own students, and I'm just really proud of you guys. These guys are 16 and 17 years old. It's still surreal that they pull this off. And Professor Galloway's smiling. He'll have you coaching his team in a couple of years when you guys get to law school. Also, it was offer, if you're ever in Houston, which maybe you won't be, come on by, visit the law school. We'd love to have you just give your tour and show you around. I think you'd enjoy your time. All right. Professor Kelso and Galloway, any questions or comments?
I'll pass it off to Rob, because he was sitting there. Josh and I asked a lot of questions. We're both constitutional law professors, but Rob is really our moot court expert. And I know he was watching very carefully. So I'm interested in giving Rob a chance to give his response to your arguments.
Yeah, no, I thought y'all all four did a terrific job. It's really amazing how good you are for where you are in age, you're going to be terrific advocates, and you already are. Let me follow up one thing on, I'm going to give you some specifics that will help you. You were direct, but there were times that when you got a question about an issue, you went, instead of answering the question directly with a yes or no, you went to the effect of the answer that you intended. And so it took a couple of sentences for us to understand what your answer was. I tell my students that anytime they get a question, your answer should be a yes or no, or a rephrase of the question, so you connect to the questioner and there's not a disconnect with anything that you're saying. Most of the questions that you're asked, if it's, does this law do this? Yes, it does. And what a few of you have a tendency to do is go to the next sentence as your answer to the question. But bring the listeners along, because we know we'll ultimately figure out where you're going. But if you don't give us that answer initially, then we're not listening to those next few things you're saying in the way that you want us to, because you want to take the listener by the hand. You know way more about this than we do, because you know where you're going. But take us by the hand. I thought the respondents did a really great job of conceding and not even attempting to fight the fight that you knew you couldn't win, because you didn't waste your time before the court on that. You just came out and said, you gained lots of credibility when you came out and did that. And I thought, petitioners, you were very responsive. You addressed what the respondent had said, particularly in the rebuttal. And there are things that are going to divide you in terms of the issue. You need to focus in on those things, because the difference between the two courts and why there is a circuit split, go and look at what are they saying the other court did wrong. And that needs to be the focus of what you're talking about, because ultimately the Supreme Court is trying to decide which set of courts is correct. And it's going to be which analytical structure that lower courts should follow and why. And so to the extent that you can do that, you are doing exactly what lawyers arguing before the court are going to be doing. But y'all did a fantastic job, and I'd be happy to have any of you on my teams today.
Wow. I'm going to hold you to that in a couple of years, Galloway. I don't know if you know who you're talking to, but South Texas has obviously the top, if not the top, one of the top moot court programs in the United States. And Professor Galloway is the coach or the director of the program. So take his words, for what they're worth. It's very grueling to make that team. Even our own students get cut off, that not only make the team. So the four of you, I think, are on your way.
Now, at this point, was this like a semi? Then we got another one, and there's one of these.
Yeah,
in final. I didn't get that clear in my mind.
Yeah, in 17 minutes, we have another match with the other two petition respondents, and so there are 4 teams today. The top petitioner team and the top respondent team will advance to the final round.
And that'll be later today or later some other day.
No. The final round will be in Washington, D.C.
Oh, well, very nice. Well, you all did a great job. I hope
you'll know later today which one.
Good luck.
Yeah, we hold the final round at the Georgetown Supreme Court Institute. It's like this scale model of the Supreme Court. It looks exactly the same, and it'll be April 25th, and we'll be there in D.C. God willing, in person. COVID, but I think we're going to be in person.
Oh, terrific. Wow. Oh, great. Okay.
Georgetown's actually lifting their mask mandate tomorrow, so we'll see. All right. Do you have any questions for us, for the students, Professor Galloway, Professor Kelso, myself?
Yeah, I have a question. How far do you guys think that time, place, and manner restrictions extend?
Oh, that's a good question. Kelso's the expert on the First Amendment. I'll let him handle that one.
Well, it's depending on which judge you're talking to, either they're likely to be receptive to it or not. It's one of those things that, you know, for those lower courts that have pretty much allowed.
Oh no, Kelso's in Zoom hell. I
intermediate review, the complex manner stuff. But you know, the thing about this problem is the Supreme Court's got, you know, this case before it, and you just know what the Supreme Court at the end is going to do. They're going to go with strict scrutiny, and they're going to strike down this New York law, and you know that's what they're going to do. It seems to me. So, I mean, the argument is good for judges who are receptive to that kind of argument, who are receptive to thinking that in many of these cases, intermediate review is the appropriate standard because you're not totally denying access to a gun, but there are legitimate state concerns with the secondary effects of lots of people walking around with concealed guns in various places, and time, place, or manner abilities to stop those concerns. For judges open to that, it's a very good argument for intermediate review. And so it's good for in a moot court like this, since the court hadn't ruled on it yet. It's a good thing to say. It's just I have fear that given the current Supreme Court, you know, the Supreme Court pre-2018 with Kennedy on it would still have been very receptive to it. I just think the court the way it is now, they're just pro-gun rights. But that's not your guys. You're still going to be arguing, and whoever makes the final round, you'll still be arguing before the Supreme Court decides it. So you can make all these arguments about sort of which set of Court of Appeals should the court adopt. It's just at the end of the day, I know what the court is going to do by the end of June.
What other questions you have for myself, Professor Galloway, Professor Kelso?
Yeah, so I have just one question, which is what exactly are your thoughts for the line to be drawn for sensitive places, as that's been a recurring conversation?
I don't know. Randy's the Kennedy expert. He has a close connection with Justice Kennedy. That's probably
that's
Kennedy line.
I mean, if you had to draw lines, you know, if you had courts receptive to thinking about, let's really think about what places are sensitive enough so there's a substantial government interest to limit guns, then you've got to do it. And it's what the petitioners in their rebuttal said. At the end of the day, it ought to be on a case-by-case basis in the lower courts. It shouldn't be the Supreme Court trying to lay down and figure out every conceivable variation of what places could be sensitive or not. You just have to do that sort of case-by-case at a lower court level. And so that's sort of the way to think about that. Unfortunately, because of what I think the Supreme Court's going to do, we're not going to have that.
No way, not a chance.
Over the next few years. I mean, that'd be one way over the next few years. You could try to clarify, you know, how far can states go and what places can they defend, blah, blah. I just think we're not going to get that lower court discussion over the next 2 or 3 years because I think the Supreme Court's going to lay down a pretty broad opinion, pretty much telling the states, you know, you've got to give the guy a gun unless you got a very good reason to deny it. I think it's what they're going to say. And but I think the best thing, I mean, you guys had a good argument. It was in your brief, and which I read, and is saying that there are legitimate public safety concerns if lots of people are out there carrying guns around at various events and then just overreacting when they get worked up. You know, road rage events and other kind of things. Just if it's not a demonstration, just someone walking around, bump somebody, they get bumped on a street walking around in downtown Manhattan, and they get really upset that I got walked into, and all of a sudden it escalates and people start pulling out guns. I mean, I think the cities have, you know, substantial interest in preventing that kind of thing from happening. But, you know, so I think those are good arguments to make. I'd make those kind of arguments. As I say, I just fear that in the reality of the world, that's by the time we get to this fall, you know, it's going to be hard for the states to regulate it in that way. But we will see. Maybe the court will take a more limited approach. Maybe they'll say, I mean, they're going to strike down this New York law because it's a lot more stringent than virtually any other state. I mean, even some other liberal states don't have the restriction that New York has. So they're going to strike this New York one down. But the question will be, in their opinion, you know, how much flexibility do they give states who have, you know, a little broader permit systems, but, you know, will those permit systems go away under strict scrutiny? That'll be interesting. The court might render a very narrow opinion about this one. My fear is they're going to render a broader opinion, striking down a whole bunch of things. But for the moot court argument on the government side, I think your arguments about the important concerns of public safety and secondary effects of lots of people having guns and their sensitive areas, yeah, I would go with that. That's the argument you should make. I think you did a good job on that.
Okay. All right. If no other questions, if the students can sign off, and I'll confer with the judges for a bit, and then we can get ready for the next match, which starts in a few minutes. So thank you so much.
Thank you very much. I really enjoyed this. I do a lot of practice rounds with our teams at South Texas, and I always enjoy it because you're dealing with people who spend a lot of time thinking about an issue and are well prepared. And this is just great fun. So thank you guys for giving me the opportunity to do this. I really enjoyed it.
Thank you so much.
Thank you so much. It's really fun for us.
Thank you.
Thank you. Yeah, it's so much fun. Thank you.
Thanks so much. Okay, students, we'll be in touch later today. Thank you so much.